This week's question of the week is as follows. My teenage daughter was out on a date with her boyfriend and they had a car accident. She received minor injuries but did require hospitalization. Her boyfriend did not have any car insurance. What do we need to do? This particular question doesn't really tell me whether there was one or two cars involved in this accident. In this particular video, I'm only going to cover the scenario of a one-car accident, meaning an accident where just the boyfriend ran off the road or wasn't paying attention and caused the accident with no other car involved. If you're a family member or a friend was injured in an automobile accident that only involved one car, the person injured in that accident potentially has what's called a guest passenger lawsuit or a guest passenger claim. They can make a claim against the driver of the vehicle for any and all damages that they sustain as a result of the accident. The first thing that you would need to do under that scenario is look to see if your daughter was listed as an insured driver on your auto insurance policy. And the second thing that you need to do is determine whether you have uninsured motorist coverage on that auto policy. If you do have uninsured motorist coverage on your auto policy and your daughter was listed as an insured driver, then you can make a claim not only against the boyfriend for his negligence, but you can recover whatever damages that resulted from his negligence. You could recover under the uninsured motorist provisions of your auto policy. You need to notify the boyfriend and his family that you're making a claim for personal injuries against him. And you also need to immediately notify your uninsured motorist carrier that you're making a potential claim against that insurance policy based on the accident involving the boyfriend. If you're injured due to the negligence of another person in an automobile accident, in general, you have a claim for personal injuries. Basically, you can recover any and all damages that you incur as a result of the other person's negligence. There is no floor on what damages that you would recover in the event that you make a claim. In other words, just because you're injured and incurred medical expenses and lost wages, there's no guarantee that you're entitled to recover any specific amount. However, unfortunately, due to recent acts of the Tennessee legislature, there are caps on your recovery on the upside in making a personal injury claim. But basically, you're entitled to recover damages for things such as medical expenses, lost wages, pain, suffering, damages for permanent injury or disability, basically any and all damages that you could get a judge, a jury, or an insurance adjuster to taste and feel and place a value on. Before you make any determination about whether you need to settle any type of claim based on that type of accident, you should make sure that your daughter is through with her medical care. And number two, you should consult with a personal injury attorney who's well experienced in these type of cases and get his or her opinion about the value of your claim. I've been practicing personal injury law for 26 years. I'd be more than happy to help you evaluate your potential claim. If there's any way that I can be of assistance to you in this type of claim, please feel free to call me at 731-423-1888. That's all for this week's question of the week. We'll talk to you next week.
Get your life back. Call the law offices of T. Verner Smith, 423-1888, 423-1888.